I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are discussing the future of health privacy in the United States. The privacy of health-related data has long been probably the most complicated area of data protection law in the United States. On top of the several decades worth of health specific privacy laws at both the state and federal levels, the FTC under the Biden administration significantly expanded expectations on how sensitive data, including health data, may be processed. And not to be outdone, states are passing an increasing number of laws that focus on the regulation of health data that is not protected by federal HIPAA standards, which in some cases is a significant amount of data. And frankly, we're likely at the beginning of this journey, not its end. To discuss these policy developments and where we can expect them to develop in the future, I have invited Jordan Wrigley to the podcast. Jordan is a data and policy analyst at the Future of Privacy Forum, a leading privacy think tank, and she focuses her work on health data policy in particular. In that role, she watches carefully the growing number of health privacy laws that are both here today and the ones that are on the horizon. So I'm really excited to have her join the discussion. Jordan, welcome to the podcast.
Thanks so much, Scott. Great to be here.
So, Jordan, one of your areas of expertise at the Future of Privacy Forum is following the many policy developments that we're seeing in the overlap between health and privacy and AI and technology, so many things kind of pulling all of these things together. And in some ways, it's difficult to sort through. And even just at a threshold level, because I think sometimes folks think about health privacy and you would just think HIPAA, right? Or you think of Part 2, or you think about the federal regulations that have been around for a very long time. You may forget, that California or Texas and other states have had a long-standing health privacy law, and that most states have had very specific health privacy obligations. But now we're starting to see these new laws pop up relating to consumer health, is oftentimes they're referred to. Maybe from your perspective, how do you sort through these? I mean, how do you lump together the consumer health versus the healthcare privacy laws and any other categories that you find helpful to try to bring order to this chaos?
Well put. So I find it really helpful to look a little bit back in time at what we're seeing and kind of understand where we were to understand where we are. So looking back in time, HIPAA has been established for a while now, and it's something that people are familiar with, consumers are familiar with, patients are familiar with, any of us in our given health role or identity are familiar with. And it's sort of set the floor for expectations in a lot of minds for how health data writ large would be treated. Fast forward many years, we've had this explosion of health, wellness, fitness, all these health supportive apps and wearables and tools that can really empower everyday people to make more informed decisions about things like sleep, eating, exercise, etc., and really support good health behaviors. Now, that was a lot of data that was flowing into those, and for a long time, we didn't really have to worry too much because that data stayed on those devices, in those apps. But now we're also seeing the value societally of combining that data and finding new things, finding new ways to improve health at a population level. So fast forward again, we had the Dobbs decision, which took away traditionally expected rights to privacy around things like abortion, reproductive health, for men, things like certain health aspects of their reproductive well-being, and so on and so forth. And so in the last few years, we've really seen sort of a supercharged lens put on health data in general. And that caused people to really notice how much data that was being collected fell outside of HIPAA and attracted the eye and scrutiny of many regulators and lawmakers. There were concerns about data being used to prosecute women seeking healthcare and trans individuals seeking healthcare, and just a lot of concern about how that data could be used to marginalize or otherwise get people in trouble. And the question was raised, is collection of this data really helping those population goals? Are we actually seeing the benefits of it in many ways, either at an individual level or at a societal level? So now we kind of have this emerging two baskets approach, which are actually touching each other a lot more than we originally thought because health knows no boundaries, no barriers, and no partitions, to put it in computer science terms. And so we are here now and we're seeing this development of extending ideas of extending HIPAA into the consumer space or just creating whole new versions of health data protections to specifically address consumer health data privacy. We see that in My Health My Data in Washington State. We saw an adjustment to Connecticut's data privacy laws, and we're seeing other things recently. Virginia, the governor just signed SB 754, I believe, which does extend similar protections to reproductive health specifically, but in general can be considered to attach to a lot of health data.
So I think, Jordan, one of the really difficult areas in this, and that overview is super helpful just to give you a sense of the size and scale of all the developments. But one important question that I know a lot of our clients come to us with is trying to understand, when do these laws apply? What constitutes health information? What constitutes wellness information, right? What constitutes fitness information? And frankly, and sometimes people asking the other question is like, well, I'm looking how broad these laws are describing healthcare. And I ask myself, what is not healthcare information under the way that these definitions work? And I'm interested in your perspective on that to try to kind of bring some more clarity about how these laws apply and when they apply. And frankly, to bring even just the taxonomy of an understanding of, when I use the word health data, does that mean that you're thinking what I intended to mean, right? Kind of basic human language kind of issues, I think, when we're talking about these set of laws.
Absolutely. I think that's step one. Recently, there was an IPP blog by Kirk Nara, which very much spoke to the frustration of the mess, as Kirk called it, around health data. And he speculates that we may not be able to fix it anytime soon. And I get to quote my partner, who is a teacher of sixth and seventh grade English here. He says, "How do you eat an elephant? One bite at a time." So, in order to address this mess, we need to start one bite at a time. And a language, a taxonomy, is a great place to start. So, for example, we've both been using the term healthcare. Healthcare to me would indicate we're talking about clinical treatment settings. My past, though, is in clinical trials and specific health data that would fall under HIPAA. So it makes sense that I would think that. But other peers in the area who deal more in consumer data that is not within HIPAA scope may think that healthcare applies broadly to things like trackers, wearables, apps, etc. So it's first great to get started with clarifying some language. How do we want to refer to and group things? And I try to use things like non-HIPAA covered data, but that's a little bit of a mouthful. It may be best for companies to set down a lexicon, both in discussing with partners, but also within. For people outside of the law and legal and policy space, something like non-HIPAA covered data doesn't necessarily indicate what kind of data we're talking about. It's just health data. So I'm thinking particularly of the wonderful marketing people in our lives. I'm thinking of the insights and analytics folks. Having these very specific terms so that everybody's on the same page will really help with communication, but also in terms of engaging with lawmakers. If we can say, hey, this is the language we're using to say, apply to behavioral data, which can mean, depending on where you're at, could mean something like mental health data in a context of mental health treatment with a medical professional. Or I've heard my ad tech friends refer to it as shopping behavioral data or consumer behavioral data to indicate they're talking about, behavior someone adopts as a grocery shop. And it's good to be clear on what we're talking about, especially because our health data ecosystems are so integrated now.
Yeah, I think really important points. And, maybe to further elucidate that is, I think one of the common areas that, organizations who, especially ones that are direct to consumer, and they find out that Washington, My Health, My Data applies, or that the New York HIPAA law will apply, or they start looking through the Connecticut or Nevada law and they start saying, wait, I'm collecting this information in the ordinary course just through my app. And my app may track my location, including, whether I attend to go visit a doctor. I'm not a healthcare company. I don't expect that I have anything to do with healthcare, right? And all of a sudden, they start seeing the breadth of these definitions and then start saying, well, maybe I, at least for purposes of this law, I am a healthcare company. And I think that it tends to really emphasize a point that you were making around the lack of a common vernacular, lack of a common language, and frankly, also hits the point of that an education in this space is imperative because as technology companies and other organizations are increasingly leaning in to use technology to improve people's health and wellness, but don't understand that the information that they're collecting is going to be treated as if they were a healthcare provider, not just kind of any other sensor-based app company, then you're going to be missing the point from an early on and will have lost really key moments in their product development and their company life cycle to get out ahead of these issues as opposed to discovering them after the fact and then having to reevaluate their products, re-architect their products, coming up with ways of trying to assume compliance burdens and compliance costs that they could have otherwise been able to avoid if they had started from the right place of fully understanding how these laws would apply.
Absolutely. And I'd love to build on that too. One of the things I find really helpful to do, in addition, step part two of creating of a common vernacular and language to share and communicate through, is thinking about how health intersects with different types of data and different types of products. I've perceived that there are about three buckets right now that I would consider existing in space. That is one, products that intentionally collect health data out front and say we are a health product, we collect health data. And then there are products that create health data. They may collect non-facially obvious health data and then do inference making or analysis to create health insights for individuals, people, or groups. And then the last one is sort of the outside part of the scope where the product can have a health impact. In this space, I talk a lot about and think a lot about conversations we're having about youth on social media, is even though they may or may not be collecting health data, making health data, the products are perceived as having a health impact on youth. So having a way to bucket a product's sort of risk profiles within those three categories I mentioned is a great way to start figuring out what actually applies here in terms of these laws, this legislation, and where are the steps we can clearly take one bite at a time to address any compliance issues or concerns.
So let's, now that we've painted this picture of a very complicated, uncertain kind of landscape, we will not have done our jobs for this episode without making it more complicated and introducing AI. And, if I asked you the definition of artificial intelligence, that could be a subject of another 1 hour episode just trying to understand what that means. But maybe from your point of view, I'm interested from a policy perspective about how the various stakeholders who are looking at these issues are thinking about healthcare AI in particular, or maybe others would refer to as consumer health AI. And, importantly, where do you see that debate evolving? We've seen, obviously a couple of laws pop up over the course of the past year. I think, all expect that there will be many more. From your perspective, what is the current state of play?
We're definitely seeing a little bit of complication in those two buckets of HIPAA, not HIPAA spaces that I mentioned earlier. Definitely seeing growth more in the healthcare space when healthcare means something like clinical or treatment spaces. We're seeing a lot of conversations happen around Chatbots and a lot of conversations happen around teletherapies, prescriptions is another one. So many of these would fall typically within sort of the rules, guidelines, and best practices of a clinical space or a healthcare provider space. And I think what I'm seeing in terms of looking at laws like those in Utah, the Colorado AI Act, and others is definitely a focus on making sure those areas, which typically create a higher level of risk than, say, most consumer level products, is regulated in a way where, for example, a patient will not receive a lower standard of care than they would if a human and non AI applied a decision or a recommendation. So we see things like human, or what I like to call provider in the loop, because not just any human should be making medication recommendations, but a provider, an expert in the loop who can look over AI decisions and say, yes, this is good, and maybe take into consideration some of the other more human aspects that are not just running numbers or considering this data that the AI may have. There's also things like consequential decision making, wherein we look at one decision that could result in a lower quality of care or in harm to a patient in that context.
I mean, interested in your perspective, Jordan, about because some of these are really complicated issues, especially around how to regulate AI, to not necessarily try to stymie the innovation, but to try to address some of those core AI oriented principles, whether that is, transparency or whether it's human oversight or automated decision making, some of the things that you're emphasizing that will have particular importance in the AI conversation. Do you see that the policy here is going to continue to develop in a very piecemeal way, similar to maybe what we've seen in California to date, where it's like, oh, well, if you're going to use a communication that is written by AI, you need to make sure that you disclose the fact that it's written by AI, right? Or you need to have the warning on a chatbot that you're talking with a computer, right? Like the very specific, very probably call it narrow versions of how to address AI oriented issues to be contrasted against, maybe what has happened in the EU with the EU AI Act, or maybe what's happened with the early version of what's in place in Colorado, or maybe even to compare it against privacy laws. In some ways, it does not look like a comprehensive CCPA oriented law. It looks more like the law that would relate to how can you use and disclose HIV information, which we've had in almost every state. So I guess that's a long-winded way of asking, what does the future look like? The best that you can put on your prediction hat and say, do we expect some sort of comprehensive version of AI healthcare laws, or is this really going to be a smattering of things that we are then going to have to weave together?
Oh, that's a great question. And I am part of the Future of Privacy Forum, so I think it's fair for me to try and glance a little bit into the future. I would say a lot of this will depend on how the next year or two goes. We see things in Colorado that are more comprehensive and all-encompassing, but like you said, we also see very, very specific laws and statutes popping up in places like California. I believe you were referencing California AB 3030, which is a great example. Um, but over the next year, I've seen, and just writing this back out to health data broadly, I've been seeing a lot of consideration around, is it best to write a giant consumer healthcare law that happens to define things like mental health, reproductive health, et cetera, in the law? Or is it better to have a very narrow singular law that covers just reproductive health? We saw that in Michigan last year. Now, this will depend on how we see companies acting too in the next few years. If we see a lot more self-regulation in industry, I think we'll see more comprehensive laws, laws that are more friendly industry friendly. But if we start seeing, I'm going to reference something that all of my friends in the healthcare privacy space will know. If we see episodes like the Target incident that happened back in the early 2000s, we will see movement into that specific space to address that specific issue and alleviate concerns, anxiety amongst consumers or patients, wherever it may happen, about those things. One great example recently is healthcare denials, healthcare claims denials. And we've seen a lot of action around AI and regulating whether or not AI can deny a claim due to wide press coverage. So that's another aspect to consider is what gets press coverage will probably also be targeted for regulation and lawmaking for sure. In my ideal world, if I could speak to the future, I would like to see, I would love to see more focus on what we have in terms of sectoral laws and aligning AI and the regulation thereof with those sectoral laws. So I do think we can peel out, again, healthcare being the HIPAA space and clinical space and the consumer space, because as part of the regulations we're seeing, the focus is what's high risk and what's not. And so doing so allows us to more effectively regulate people based on, or companies based on something like a business model or whom they're interacting with, which is in the end what HIPAA kind of relies on, is an entity-based regulation, which in the end may be more effective than trying to regulate the whole of a very massive, very messy, to quote Kirk again, and very ambiguous sometimes, big glut of health data writ large.
I mean, do you see then, Jordan, as I'm, anticipating how this will evolve, right? Because we have what, 20 or so states now who have their comprehensive versions of their laws, some of which have very specific angles around sensitive data, which would include healthcare information, but also be much broader than healthcare information.
Mhm.
And then we've seen some of those same states add on their own consumer privacy, health privacy law. And now we're seeing some of those same states have their health AI or AI oriented states. I mean, is the net result, if I fast forward this conversation, and we're having it 5 years from now, that we're going to see many of those same states who leaned into comprehensive privacy to have a comprehensive, or not a comprehensive, but have a consumer health privacy law, and maybe ones that are specific to AI. I mean, is that where the direction of travel is from your perspective?
I think so. I think it's fair to say if a state already has one comprehensive law that appears very effective, then it's fair to say they might make more. So, for example, Washington State has a comprehensive privacy law, has a comprehensive health privacy law, perceivably too, and then may also make a comprehensive AI law.
Yeah, interesting. One specific thing that I wanted to call out here, because I know it's an area that I think we probably both get a lot of questions about, and it's the importance of having some standardized view of what de-identified or anonymized data means in the healthcare space. Given your background in the research community, you probably recognize the importance that de-identified health information has to innovation in this space. But it's also, frankly, you mentioned the Target example of, where information that was thought to not have identified an individual ended up identifying an individual. And so I think it's an area that we frequently see under scrutiny, including the HIPAA standard for de-identification that was implemented 20 something years ago. Where do you see the future of of the de-identified exception? Is that still holding, or do you feel like that will continue to be cut away?
I know this is a very hotly discussed topic. My impression, giving my personal opinion, is that de-identification as we have known it needs to change. And AI is part of that, that what was once de-identified is no longer. And we can't necessarily cookie cutter apply the same techniques. That technology has simply gotten too sophisticated, and we need to evolve with the technology in terms of looking at de-ID'd information, de-ID'd information. And so I think one important thing to distinguish in the health space, whether healthcare or consumer health, that's really important is a company or use seeking to identify a person, a condition or health condition, or both? I would say seeking to identify a health condition by and of itself without necessarily identifying the individual, things like rare diseases aside, is not necessarily within the scope of some laws. Definitely some, yes, but I would say, for example, um, uh, Connecticut's law suggests that one would need not only to identify the individual and their condition, but both at the same time in order for it to be a concern of privacy when it comes to health. So I think for the purposes of de-identification, we're going to need to shift and evolve into a future where it's very difficult to completely de-identify something in totality. And I don't necessarily think that's something we need to be afraid of. In many cases, one of the best ways to address the problem is to start by admitting there is a problem, and that's that things are really, really hard to de-identify effectively anymore, which can kind of speak to our innovation of and sophistication in the technology we've created. But I do think at sort of the nexus here too is security. When de-identification fails, when, basic privacy practices fail, security is sort of the next in line, which speaks also to something I've seen a lot of, which is privacy and security becoming more in conversation with one another in terms of what do we do first and then what do we do second. So I think definitely shifting to more of a collaborative stance and posture between those two is going to be one of the most effective ways to identifying not just whether or not something's re-identifiable, but when we can't be sure that it is, how to protect it.
I mean, it's almost like I'm interested for your reactions to this, but it's almost, in my view, similar to maybe some of the debate and kind of evolution that we're seeing maybe in Europe right now around the use of scraped data for AI training, right? Which, I think probably there would be much more of a chorus in the very beginning saying, can never do that. And then they realized, well, they did it. And, that's how we were able to generate these LLMs. But it's not that they say that, like, well, now you have to just dispose of the LLM because it was used against data that may have been received through the public internet. In some ways, like that, the opportunities for health seems like it's the same kind of thing, right? We all really want to have the outcomes of the benefits that would come from the uses of this information. And de-identification, anonymization, pseudonymization may be privacy protective means by which you're helping generate the technology, but it is not foolproof, at least with respect to the AI right now. And so if I'm understanding you correctly, maybe that's recognized within the policies world, and that we can anticipate a different dynamic than just saying this data set has been de-identified, thus it's not subject to these obligations or these principles any longer.
That's well said, and I think you're absolutely correct, Scott, and that what we try and hang on to, and I know we often talk about how slow policy moves in comparison to technology, and I don't know if one needs to move slower or one needs to move faster, but we definitely need to realign and harmonize what we are doing in policy with the technology we have now.
Yeah. So maybe as we kind of bring the episode to a close, we spent a lot of time talking about state laws, which obviously is the focus of you and me because that's where all of the action is right now. And there's been long-winded debates at the federal government around whether there should be federal privacy legislation, not necessarily specific to healthcare, although I think, there's been calls to modernize HIPAA, for example, at the federal side. The prior SFTC or the FTC under the prior chairperson was very much leaning into the application of Section 5 of the FTC Act on sensitive data, including health information. again, putting on your using your crystal ball, using your role at the Future of Privacy Forum, where do you see the developments, if any, at the federal side, maybe in the next couple of years during this current administration?
That is deeply hard to say. Hard to predict here, but one thing I will challenge that I have seen and I do disagree with as a characterization of this administration is that all health, consumer or healthcare or otherwise, legislation, regulation, or enforcement is somehow going to stop. It may lessen for sure, but the populations, this administration, the constituents that align with it care about privacy too, just in a different way. And I try and go back and think about if Dobbs had not happened, if we hadn't sort of supercharged this debate around sensitive data and consumer health data, what would it have looked like had a similar individual been elected to office in that case? How much would have changed? Would it have changed at all? What priorities can we look at from the past to see into what else we might happen in the future? Now, I don't know how often we're going to be able to apply lessons from the past to our current, present, and near future in the policy world, but I think we can at least apply some. And we can think clearly about what this means in terms of past 4 years from now as well. Do we seek out more legislation, more regulation at the state level, or do we move things back to the federal level? And what does it look like if 4 years from now we have mountains of state legislation? Can we make it work? Can we harmonize? And what are the downsides to it? And then lastly, I'll say, in terms of crystal ballness around states, we'll definitely continue to see a little bit of conversation happening between the states who are more aligned with the current administration and less aligned with the current administration, and how that will work out. And if we do actually manage to create legislative barriers to keep data from flowing across certain places at certain times.
Yeah, I think that's 100% right. I mean, and I do think, to your point, which is I think the right one, is that while enforcement and scrutiny around data may differ in this administration than the prior one, that does not mean that it differs in the way that the new administration under the leadership of Chairman Ferguson means that data is no longer area of the focus. I think we've actually seen that very recently with updates that came out yesterday around how the FTC was looking at the disposal of genetic information in connection with a bankruptcy, right? So it's not a turn the blind eye, hey, you can do whatever you'd like over the course of the next 4 years. Far from it. It may look more traditional, or what we think of as people who've been around this space for a long time, the traditional style enforcement of a deceptive and unfair trade practices, and not necessarily leaning into the development of new law in the application of those, which I think the Lena Khan, tenure probably was accused of, in terms of really moving goalposts at times. And perhaps maybe that goes away and we look more of like, with more certainty, this is what needs to happen. But for sensitive data, it's been the longstanding principles that sensitive data, like health information, need to be subject to a heightened degree of privacy responsibility, a heightened degree of security obligations, and that would be, with borrowing your crystal ball for a second, I don't imagine that's going to change, especially when you think of that data in the application of using that data by big tech, which is obviously been another area of scrutiny by the administration.
Absolutely. Well said.
Well, Jordan, I really appreciate your time and the expertise that you share. Every time that you and I connect, I feel like I walk away learning a little bit more about the space. So I appreciate your sharing those insights and many more with our audience.
I feel the same, Scott, and thank you so much.
Well, with that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.